2017 CF 15684, State v. Nelson, back from our brief recess. Could counsel approach? All right, Mr. Nunnally, is the state ready to bring in the jury?
Yes, Judge.
Ms. Simmons, defense?
I'm sorry, I didn't hear
Are you ready to bring in the jury?
Yes.
Mr. Nelson?
Yes, Your Honor.
All right, let's bring in the jury, please. All right, members of the jury, I apologize. There's some matters I need to take. Forgot something I need to address with the parties outside your presence before I address you. So I'm going to send you out back to the jury room in just a moment. You're going to continue to leave your notepads and your pens here. During the recess, you're under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. Please follow the deputy to the jury room. We'll bring you back as quickly as we can. Thank you. Counsel, please approach. Can counsel approach? All right, Mr. Nunnally, is the state ready to bring in juror 272?
Yes, Judge.
Ms. Simmons, defense ready?
Yes, sir.
Mr. Nelson, have you had a chance to talk with your attorneys about what we've been talking about here at the bench?
Yes, Judge.
All right, are you ready to bring in juror 272?
Yes, sir.
All right, let's please bring in juror 272. All right, juror 272?
Yes.
All right, deputy. I'm handing the deputy this note that we received. He's going to hand it to you. All right, and on the back, could you read what's on the back?
No from juror on 7/9/19?
Okay. That note is, did you write that note?
Yes.
Okay, if you could hand that to the deputy. Thank you. All right, juror 272, if you could please just share with us what you saw and what you heard that led you to write this note.
Two of the jurors came to the jury room before the day. One said she felt scared, the other said there was a man that made a comment to them that the defendant needed to be fried. And then she also asked one of the jurors her age, and they said he punched a window, and that the security guards were present, but they were scared.
And do you know the juror numbers of the jurors that reported what you just shared with us to you?
115 and 30.
Juror 115?
Yes.
Okay, and juror 38?
Yes.
Did any other jurors report what you just shared with us to you?
There were several jurors talking about it, but those are the two that actually reported it and gave details. They had said earlier the man was in the courtroom making strange gestures and mimicking one of the people that was testifying. I believe they contacted you about that, right?
When you say they, who are you referring to?
One of the jurors, she's sits the second seat, I believe, the second or third, black female with long hair.
In the front row?
Yes. But actually, she spoke to you about the man that was in here when it happened. Yeah,
Is that, you know the juror number?
I know.
But it's the first row?
Yes, the row line.
Is it in this, do you know the second seat or the third seat?
I believe it's the second seat.
Juror 874?
I don't know her number. She's a pregnant female.
Okay. Other than what you've already told us, do you know the juror numbers or either juror numbers or seat numbers of any other jurors that saw or heard anything related to the subject of this note that you wrote? Counsel approach. All right, Juror 272, would anything about this affect your ability to be a fair and impartial juror? All right, Juror 272, in a moment, I'm going to send you back into the jury room. When you go back into the jury room, again, you're going to leave your notepad, your pen here. Again, you're under all the court's instructions. And also, you're not to discuss any of the questions or any of the responses you've given here in front of us today in court regarding this note that you wrote. You understand?
Yes.
Okay. All right, please follow the deputy in the jury room, and we'll bring you in as quickly as we can. All right, do both state and defense want the court to bring in the two jurors who are identified?
Yes, sir.
Any objection to that? All right, if we could please bring in juror 115. All right, juror 115?
Yes.
It's the court's understanding that you had some interaction with a person outside of the courtroom. Is that correct?
That's correct.
All right, could you just share with us what happened, what you saw, what you heard, everything that happened?
Okay, sure. There was a male outside and he was pulling on the doors. We heard some commotion in the hallways, but we were sitting on this side in Ariel, so we didn't actually know what was going on. So after we saw someone from the state go to the bathroom and come back, after she came back in is when he came around. And he started yelling and he punched the window, the blinds out there. He punched it and his hand started bleeding and he was like, oh, I want to punch someone in the face. And we were just looking like, what's going on? We don't know who he is. So then he started yelling, do you know what's going on in there? And then Ariel, she was like, no. And he was like, oh, I hope he fries. And she was like, let's go. You know, she was saying, let's go. She got up and she said, let's go. And he didn't say anything to me the whole time, but he was trying to talk to her, but she was just so frightened by him because he was so close to her. So we got up and then there was, I guess, some lawyers in the hallway, and we were like, can you help us? And they were like, oh, we can't talk to you. And we're like, no, we're not trying to talk to you. We need help. We need someone to help us. Because he's yelling at us and he's walking through the hallway. His hands is all, they're bloody. And we just need to basically get away from him. And so I guess they called someone, because then I started to see the state troopers in the hallway. And so he left after that.
And the juror that you were with, do you know the juror number of the juror you were with?
I think it's 85, I'm not sure.
Do you know what seat the juror is sitting in?
I think she sits in the back, the second one to the last.
In the back row? The second one from your left, or my left,
Well,
1, 2?
yeah.
Okay.
And then we also told, I'm not sure if it's in here. Yeah, we spoke to him. Yeah, we spoke to him in the hallway. We were like, there was a guy.
You're talking about the deputy?
Yes, deputy. We told him also when we saw him, we were like, because we actually moved from him, from this guy that was out there yelling at us. We actually moved. And then when we saw him, we actually let the deputy know that there was a guy on the floor as well.
Other than what you've already told us, anything related to that incident that you can share with us other than what you've already told us?
No.
Any counsel approach? All right, Juror 115, would anything about this affect your ability to be a fair and impartial juror?
No.
All right, ma'am, just a moment. I'm going to send you back into the jury room. When I send you back, you're going to continue to leave your notepad and your pen here. You remain under all the court's instructions. In addition, you are not to discuss any of the questions or any of the responses that have been given here just with you privately with the parties and with the court. You understand?
Yes.
Okay. All right. Please follow the deputy in the jury room. We'll bring you back in as quickly as we can. Thank you. Any objection by the state to bringing in juror 38?
No.
Vince?
No,
Mr. Nelson?
No, Your Honor.
All right, let's bring in juror 38, please. All right, juror 38. All right, it's the court's understanding that there was some interaction that you had outside of the courtroom here with a male individual. Is that correct? Okay, could you just share with us everything that happened, what was said, what you saw, everything that happened that you can recall?
So me and the previous juror, we were talking like just casually outside. And this man, like he just came upstairs, he was yelling, he was like, "Oh man, you're in the house. This is what you want." So like I got scared. She was like, "Should we go downstairs?" But she's like, "No, like let's not worry about it." So we sat right there talking. And then eventually he made his way over to us. He was like, "Go on the court doors." Like a little bit to be found. He punched the window, his nose was bleeding. Then he came over and he sat like next to me. And he's like, he was talking about, he was like, "Have you heard about the case?" And we're just like kind of looking at each other. He was like, "He deserves to fry, he deserves to die, he beat and murdered a woman." And that's when he got up and he was just talking. And then he started asking me, he was like, "How old are you? What school you go to?" Like he was really young. And then that's when I was like to the other juror, I was like, "Let's just get up and like go to the bathroom, like let's just walk away." And then as we started walking away, he was like, "Oh, you must be scared." So we just went to the other side, and then I like told some name, I'm not even sure, we called him that. He wasn't a deputy, but he worked here. I was like, "Is this man like he's like really going crazy?" Because I was scared. And he wasn't a deputy before. I was like, "He's going really crazy." And then, but he went on the other side of the floor, and we didn't see him. I guess we went downstairs. I did talk to that deputy over there. He was just like, "If you see him again," because I told him what happened. He was just like, "If you see him again, like just let me know." And that was it.
Other than what you've already told us, anything else that you recall that was said or you saw, heard, or anything else about that incident that you can recall? And the other juror that you referred to that was with you, do you know the juror number of that juror? You say sits right there, the front row? So farthest away from you in the front row, and then there's two chairs, one behind the other. Is it the front or the back seat? Okay. Council approach? All right, juror 38. Would anything about this affect your ability to be a fair and impartial juror? All right, in just a moment, I'm going to send you back into the jury room. You're going to continue to leave your notepad and your pen here. You remain under all the court's instructions. In addition, you're not to discuss any of the questions, any of the answers that you've given here in court with just you present in the court and the parties. Do you understand? All right, please follow the deputy in the jury room. We'll bring you back as quickly as we can. Thank you. All right, can counsel approach?
Your Honor, we're requesting a standard instruction that's in the instructions we've been going through. On the second to last page, it's under the rules for deliberation, number 2.
Number 2, under rules for deliberation.
Yes, Judge, and we're just discussing whether something needs to be added regarding anything that happens outside the courtroom. If I could just have one more moment. Okay, Judge, thank you. We would ask that number 2 from that page, rules of deliberation, be read, and perhaps a sentence afterwards, anything that may occur outside the courtroom or any opinions expressed to you outside these proceedings cannot be considered.
So, under rules for deliberation, number 2, plus that sentence that you've written down on that piece of paper that you just showed, Ms. Burdick.
Yes.
Any objection from the state to that? No. Okay, if you could,
And,
yes.
and do you have number 2, or would you like that as well?
I do, just so we're clear, what I have is your decisions must be based only upon the evidence that you have heard from the testimony of the witnesses, have seen in the form of the exhibits and evidence, and these instructions. I don't know that that makes sense in this isolated context.
Yes, Judge, that's why we asked for the second sentence.
What about just this piece of paper? That is, anything that may occur outside the courtroom.
That's fine too, Judge, if you just want to read the written proposed instruction.
Okay, so just make sure I'm reading this correctly. Anything that may occur outside the courtroom or any opinions expressed to you outside these proceedings cannot be considered.
Yes. Sorry for
Ms.
the
Burdick,
delay.
no objection to that? Okay. All right, Mr. Nolly, is the state ready to bring in the jury?
Yes, we are, Judge.
Ms. Simmons, defense?
Yes, Your Honor.
Mr. Nelson?
Yes, Your Honor.
All right, let's please bring in the jury. Mr. Nunley, does the state acknowledge the jury?
We do, Your Honor.
Ms. Simmons, defense.
Yes, Your Honor.
Mr. Nelson?
Yes, Your Honor.
All right, members of the jury, anything that may occur outside of the courtroom or any opinions expressed to you outside these proceedings cannot be considered. Members of the jury, in just a moment, I am going to excuse you for the day. We have been working, we're continuing to work. There's some things that I think we need to continue to do outside of your presence that don't require you to sit around waiting in the jury room. So in a moment, I am going to excuse you for the day, just to give you sort of the lay of the land. My expectation is tomorrow that we will go into closing arguments. Then I will instruct you on the law that's applicable, and then you will retire to begin your jury deliberations on a verdict. So tomorrow, you do, again, need to bring your bag. So again, I ask you to review the sequestration packet that you all indicated you already had. Review that again, make sure you have everything together. Bring your bag tomorrow. We'll plan to begin closing arguments at 9 a.m. tomorrow morning. During the recess, you are going to continue to leave your notepads and your pens here. During the recess, you're still under all the court's instructions, including but not limited to the instruction not to discuss this case amongst yourselves or with anyone else. And continue to be under the instruction not to do any research, listening to media reports. All the court's instructions remain in full force and effect. I do thank you for your service here today. Enjoy the rest of your evening. We'll see you tomorrow at 9 a.m. All right, Mr. Lahr. Sorry for the lengthened hiatus there, but were you able to find the portion of the standard that was what you were referring to as the Supreme Court's attempt to address this concept?
And actually, thank Mr. Greenberg for finding it for me. It's actually, if you look at the blue part of the instructions that we gave you, and you go up 2 paragraphs.
Wait, I'm sorry. So the language that is highlighted and underlined, which is the defendant's requested addition, okay, above that?
You go up to 2 paragraphs. And
2 paragraphs. Okay, I see it.
So,
The law neither compels nor requires you to determine that the defendant should be sentenced to death. Okay.
and so the Supreme Court said, okay, this is good enough for a jury instruction. However, last year, I was in a death penalty case involving Chanel St. Simon, 48214 CF 12661-A. And I sent the court a copy of it, and starting on page 6035, the state attorney started talking about, we're a nation of laws, we're supposed to follow the law. Then he started to go down into discussing about mercy. And what he says about it is that
And I'm sorry, is this closing argument?
during closing
Oh,
argument.
okay.
And he says, he starts to talk about the fact that the argument from the defense would be mercy, and talked about mercy and being the result of the individual judgment. And he says, starts to talk about the fact that you will not find I'm sorry, on page 6036, starting at page, line 1. Then she told you in an opening statement that you should rely on your own individual sense of mercy. You can scour the instructions you receive, ladies and gentlemen. You will not find anything about an individual sense of mercy. It is not there. And that's problematic, because you will not see the word mercy anywhere in our instructions, because it didn't articulate that by the Supreme Court. It basically said, well, you don't have to, you're not required to do it. It doesn't talk anything about mercy. And the problem with that is, and I think the state attorney used that wrongly, of course, was to say that if it isn't on paper, it doesn't exist. And when he starts his argument saying, you must follow the law, and if it's not in the jury instruction you receive, then you can't consider it. He didn't specifically say that, but he suggested it wasn't there, and the suggestion was if it's not there, it doesn't exist. And the problem that is compounded is the very last thing you read to the jury, which is basically, you must follow the laws as it is laid out in these instructions. Again, if you don't see mercy there, then they may not understand that mercy is a valid consideration. No matter how much Ms. Simmons can get up and say, you can rely on mercy, if it's not in those instructions, you're essentially telling them the same instruction, if it's not in here, you can't consider it. You've got to follow the law. And so what we're asking for is a bright line type of wording for the jurors to be able to say, yes, you can consider mercy. And I think we've laid out an instruction that pretty much handles everything that is allowable according to the Constitution. And as I said, again, it doesn't say mercy anywhere in there, so the question is, how the jury is supposed to know, that they can consider it. So,
Okay. Okay. Who's going to respond for the state on this? Okay.
First off, the case that counsel references was not prosecuted by the Ninth Judicial Circuit. It was prosecuted by Mr. King's office out of the Fifth Circuit. It may have occurred in this courthouse, but that's a completely different office, and so I believe it's inappropriate for counsel to even reference an instruction similar to the one that is given in the federal system. And because it is absent from the instruction, we can only conclude that they rejected that. According to counsel, their attempt at including language suggestive of a jury's right to consider mercy in their decision-making is the line that he made reference to, where the law neither compels nor requires you to determine that the defendant should be sentenced to death. The fact that the word mercy does not appear in that paragraph or in that sentence should tell us that the Florida Supreme Court did not intend to have a jury in a capital case instructed specifically on mercy. The instruction that counsel requests is modeled after the federal death penalty statute, unrelated to Florida's. And so I would urge the court to reject that as instructive out of hand. One of the glaring differences between the federal death penalty statute and Florida's is if a federal jury says somebody should be sentenced to death, they are required, the court is required to sentence that person to death. That is not the case in Florida. The court can always override the jury's recommendation. So it's comparing apples and oranges. It might be the same idea, but trying to bootstrap this instruction that's used in the federal court into our court when it's clearly been rejected in the most recent iteration of the instructions by the Florida Supreme Court. Additionally, I provided counsel with, I believe I provided counsel with the case in the court, Thomas James Moore, 820 Southern 2nd, 199, a Florida Supreme Court case from 2002, directing the court's attention to first head note 24, and then a discussion at the bottom of the 8th page of the printout, which says we have also held, and this is an ineffective assistance of counsel claim, we have also held appellate counsel not ineffective for failing to argue that the trial court erred in refusing to give a penalty phase jury instruction that the jury could properly consider mercy during its deliberations when the court gives the standard penalty phase jury instruction and advises the jury that it can consider any